Hey, good afternoon, everybody. I'm Neil Kalin, joined as usual by Michael Simkin. We're here with the real property section. What's up with us? Sort of almost every monthly webinar, every month webinar. And we're here. We got some good cases to talk about today. And we've got a brand new feature that we're going to talk about with you today. So give me just a minute. There was something I needed to check, and I apologize. I should have done this right before I loaded everything up, so hold on a moment, please. Okay, here we go. So I'm already sorry about that. So again, good afternoon. I should have just had Michael, chat on while I was looking something up. But welcome to the November issue of What's Up With Us, our monthly real property law section discussion of new cases. And today, featuring a brand new feature, Michael is going to give us some tips on how to practice law. And I'm assuming a lot of this has to do with your litigation practice, Michael, that we are calling Simkin Secrets. So let me change my slide here so you can see what we're going to be doing this month. Here we go. So we're going to start off, Michael, with Simkin Secrets. Then we got a couple of interesting cases that, our sort of theme this month is marijuana. And we're going to see how that ties into both the J.C.C. Randall case and the Mueller case. We do not have an interview this month. Then we're going to talk about electronic signatures and what you need to prove in order to establish you have an agreement to bring a motion to compel or to have an enforceable motion to compel arbitration. And then we don't do a lot about bankruptcy, but there was an interesting case I saw here, the In Ray O'Gorman case, that I thought would be of interest to real property practitioners. So, with that being said, I'm just going to turn it over to Michael, who's going to tell us his first secret. And depending on how this goes, what we're going to try to do a couple of times next year, we won't do it every month, but we're going to try to do this a couple of times next year where Michael will give one of his secrets, his helpful tips, and we're going to try to do this so that you can get some of those specialty credit hours, at least a half an hour's worth. But we're going to work on that for next year. Today, it's just to help you in your business and your practice. Take it away, Michael.
All right. Hi. So in some of the cases we have today, we have we'll call it a mediation issue, and we also have some discovery issues. So I'm just going to mention a few things. And if you guys have anything you want to ask me about in the chat, feel free, or call me or email me later. I'm kind of like the type of guy that's technical and really gets into discovery issues. So I feel that I'm pretty well versed in it, but a couple hints I want to like put out there is the first one. We'll talk about discovery for a minute. Courts hate discovery disputes, just despise them. So the first secret I really don't want to mention, but I'm just gonna put it out there. Basically, if you file a discovery motion, it's usually going to be granted because courts kind of, I think, skim over it and just say, who cares? If there's some evidence, share it. That's the bottom line. And that's true. The bottom line is we don't have trial by ambush. You're supposed to share it. And judges just hate these things, okay? And unless you can express very concisely, there is a work product privilege that I don't need to share with my research that I found on this issue in the middle of this case, or something really legit. They just don't care. Okay. Now, I've seen that backfire. The way it backfires, by the way, is when people file basically form discovery motions to compel further responses. And I'm only talking about further responses. If it's a discovery motion to compel an initial response, yeah, it's going to be granted, but you better show the court that even if there's no meet and confer requirement, that you try to resolve it, because this is going to get mad at you for wasting their time. Um, Today with emails and service by emails, you know, sometimes people don't get their emails. So don't just fire off your motion to produce initial responses. Call the person on the phone. I know that people under 40 don't want to use the telephone anymore, but call a person, because it's possible the email went to an online spam filter or something else. So just don't surprise them. That will not work out. On a further discovery response, the courts,
Michael,
yeah,
before you move on, so I of course cannot speak for those under 40, but having children under 40, I have some concept of what's going on with that generation. And even if you do not want to send a message, if you know that the phone number you have is a person's mobile or cell phone, then send a text because everybody looks at their texts.
that's true. If you're a younger person, the text, you have to respond to it instantly. And if you don't, then it's like a big problem. But anyway, just don't waste the court's time with something that the first thing out of their mouth is, okay, I'll grant this, but why didn't you call the guy? Why did you file the motion? And they're not going to give you attorney's fees or something like that. Okay, the further responses, if you're someone that's filing these form motions to compel further responses, or the only thing you're upset about is someone, you know, asserted some objections, but without waiver of the objections, they answered it. Courts don't like that either. That's just a waste of time. Okay, courts can deal with objections at the time of the trial. But keep that in mind. We'll go to the next part, something more substantive. Um, this is about the beginning of the case. And in the beginning of the case, I actually learned this from my law school professor, and I remember her name. Her name was Connie Roca. And I think she became a lawyer like sometime in the 40s, I think. I don't know. She was a great lady, but she was a civil procedure queen. She worked in defense, like for insurance companies. But I remember she told us in the beginning of the case, serve form interrogatories on your clients because you need to learn the facts. And when someone has to answer a questionnaire, okay, but why have them answer some generic questionnaire? You're going to have to answer form interrogatories at some point or another. Give it to your clients, have them go through it, and you're going to learn a lot about your cases, and you're going to learn what your client doesn't know, and that might lead you to something. So always give your clients form interrogatories when you sign them up, or a couple days later, in the beginning. Okay. The other thing that I want you to really I want to harp on is these objections. Okay. While you can object to things and say it's compound, it's vague, courts really don't like those. I mean, if you can kind of understand what it is, it's fine. One thing courts usually will support, though, is if someone's asking a question, you know, provide all documents that are related. Usually they don't go along with these words like related because you need to have one concept per discovery question. So don't do these things related. And the other thing that's a pet peeve of mine is when people say it may be a demand for documents, provide all documents that are responsive to your questions to the form interrogatory set one. You can't do that. That's called an omnibus question. You can't say, here's one question that plot applies to maybe 32 other questions. You can't do that. There's no case that says you can do that. Okay. Keep those in mind. Okay. And here's a secret about document demands. Okay. It's not what you call sharp practice. Sharp practice is when you're like maybe doing something that's technically correct, but it's just like evil. Don't be evil. Courts hate evil when you just lose credibility. You can't do that. This is about as close to something like that that I think is kind of okay. On your document demand, you usually put down the date for production. And that date production is going to be 30 days plus the service. You serve it by mail, you had 5, serve it by, email or FedEx, a couple of business days. Well, one thing you could do is on that date for production, you can put a date that's 1 or 2 days past the 30 plus service date, because if people are sloppy, and I see nothing wrong with taking advantage of sloppy people, when they receive it, they see date of production, December 5. But December 5 happens to be 37 days. I mean, not 30, it's going to be like, yeah, say 37 days after service, or maybe it's 34 days after service and you served it by email. So they calendar that. So when they serve their responses, they're late and technically they waive their objections. So one more time, instead of doing 30 days plus 2 business days or plus 5 calendar days, add another day or two there. Now, here's what's going to happen. I would say half the time the people make a mistake. When they call, when they assert objections, you say, by the way, you're 2 days late with your service of the responses and you're dealing with them. Don't be a jerk, okay? Tell them, I'll tell you what I'll do. While you waived your objections by not filing a timely response, which is different than the date of production of the actual documents, let's talk about your objections. And you might say, look, I see here you asserted attorney-client privilege, but all I asked for is a copy of your driver's license. There's no way your driver's license is privileged. So just talk to the people and work it out, because you get back to rule number one of courts hate discovery motions. And if your discovery motion is wasting a lot of time on something that's not important, it could go either direction. Okay,
So
the other, yeah,
Michael, for a non-litigator like me, if you could maybe briefly explain that difference you're talking about, because you're sending out a request and you're telling somebody they don't have to respond to a certain date, but from what I hear you saying, no, they have to respond before that. So you kind of
okay.
lost me there.
All right, so on a document demand, not in an eviction case, say, where it's at 5 days to respond, you have 30 days to respond. In a document demand example, you have 30 days to respond plus service. The response is going to consist of, you have to write down, will comply with the demand, will comply in part with the demand, or maybe objections, like objection, it's overbroad. You can't say everything related to the purchase of the house. People say very broad categories. Produce all documents that are related to your purchase of the house. Okay, you can't do that because the document demand has to be one category of documents and a specific category of documents. It has to be produce all documents, maybe relating to your property inspection of the property, but you can't say for your purchase of the property. So the first thing you have to do is, after 30 days, provide a response of objection, or will comply, or will not comply, or will comply in part. The next part is actually producing the documents. So
Thank you. Okay.
that's the difference.
All right.
Okay.
Yep.
Um,
Great. Thank you.
so now there's one other thing I want to just mention briefly. This is going off the discovery document thing for a moment. We have a case that has an interesting type of mediation. I think they call it collaborative mediation. It's in the case we're going to talk about called Mueller. This is something that you have to be very careful of in a case. I believe people need to settle cases before either side learns the strengths and weaknesses of their case or of the other case. When you first have a client, they only tell you their side and it's only part of their side. Eventually, you're going to start to respond to discovery and you're going to learn about the case. You might respond to a demur or something and you're going to learn some legal things about the case. But wouldn't it be better to have an early mediation and try to settle the case before either side knows what is the problem? Okay. It also saves a lot of money. Okay, so that's really important. And I try to do that all the time. It also can come in handy because at the time, say the case is finished, and if there's a judgment and there's an attorney fee clause, you might say, hey, I tried to have a mediation in the very beginning of this case, and the other side said, I refuse. I'm not going to mediate until we complete discovery and I take depositions of people and stuff like that. And the judge might say, well, you just lost on a summary judgment motion and you didn't have a case and you should have known that because your client knew about this issue. And if they didn't tell you, that's kind of like your problem. You should have listened to the other side and done an early mediation. So now that you've lost the case and they decide to spend $100,000, I feel I'm going to give them $100,000. Okay, and that is, I've seen that happen multiple times. Okay, so try to settle the cases early on, or at least have it documented that you try to settle a case. It's also important on pocket cases, cases like employment law cases where there's a private attorney general attorney fee clause that you're concerned with. If you could show the judge that a reasonable attorney fee is not $95,000 for a $5,000 wage and hour claim, and that you tried to settle the case in the very beginning, that court is going to say this case should have been settled early on. And one side offered to go to mediation and the other side didn't. And it comes up in those employment law cases too, because they're mills. Employment law lawyers, I'm not saying anything bad about them, I kind of am friends with some of them. They take hundreds of cases and they don't want to be out of pocket $5,000 for mediation or even an inexpensive mediation. There are places, and if you need help, I'll tell you where to go. $500, $1,500, you get like a 3-hour professional mediation. Okay, so at least propose, go to this place. They have a $1,500 per side mediation, with a retired judge even. Let's try that. Okay, that's very important. What do you think?
Okay, Michael, thank you very much. I certainly learned something this early afternoon, and hopefully some of our listeners did too. So let's now jump into our cases today. And the first case is J.C.C. Randall versus Santa Barbara. And let's see what happened here. Well, we've got Santa Rita Holdings, which wanted to get a conditional use permit to cultivate cannabis, marijuana, on property that I'm assuming it was leasing because it says the property is owned by Hughes. In order to issue the CUP, the county needs to find that the streets and highways are adequate for the proposed use. But the only access to the property is over an easement for ingress and egress of property that is owned by Crandall. Crandall objected to the CUP. Now, the ingress and egress road, so to speak, was a dirt road, but the county said it was wide enough and it was sufficient to provide adequate access to the property. So the county approved the CUP, and Crandall appealed to the Board of Supervisors, and the Board of Supervisors denied the appeal. So then Crandall petitioned the trial court for a writ of administrative mandate. Now we're getting into technical stuff that's just that procedural stuff, which always throws me for a loop, but he wanted to challenge the county's determination. The trial court denied the petition, and Crandall appealed to what we have now, the California Court of Appeals, Second Appellate District, Division 6. And the Court of Appeals start off with analysis saying, what is Crandall essentially doing? Crandall saying, I have the right to exclude parties from my property. That's one of the essential, right? What did we learn in law school? A bundle of sticks. That's one of the sticks in the bundle of sticks, the bundle of rights of real property ownership, the right to exclude. And Crandall says, I want to exclude somebody who's using this property for cannabis purposes. Whether Crandall really cares or not, we can't tell from this case, but that was the argument that was raised. Okay. And the court said, well, Crandall cannot be forced to allow his property to be used to transport cannabis because it exceeds the scope of use allowed under the easement when the easement was originally granted. And it was granted in 1998. 1998 was before California adopted its laws. You can see the code section there, Civil Code 1550.5, that for all intents and purposes, and at least for the purpose of this case, makes the use and operation of cannabis facilities permissible in California. But at the time the easement was granted, that was illegal use under both federal and California law. and the court looked at the easement and says, well, something was illegal then, even if it's not illegal under state law now, it was illegal then. So you are changing the use, you're changing the scope of the allowable use of the easement. And Crandall, as the servient tenement owner, has the right to object to that use. If Crandall objects, then there is no access to the property. So how can the county grant a CUP if there's no way to get the agriculture, right, as they're calling it, on and off the property? And it's a really, I think, an interesting case. And to me, my favorite quote in this case is down at the bottom of your slide, which is, this is direct from the court, and this is how the court starts the opinion. Many Californians have high expectations that cannabis is legal in California. This is a reasonable assumption because the Civil Code says it is. We regret to inform that cannabis is illegal in California because federal law says so. So while this case may have to do with easements, may have to do with exceeding the scope of easements, may have to do with conditional use permits, you get really broad statements in this opinion that might be useful or detrimental, depending upon your point of view, in a lot of other instances in California. Michael, you're a little bit in the dark here, but it looked like your eyes kind of widened a little bit. So tell us what you think about the Crandall versus Santa Barbara case.
All right, so I'm kind of like a goofy, I'm kind of like on both sides of it. So I do represent some cannabis, you know, businesses, I guess. But
Growers? Okay.
but
Growers or
I
business?
the ones that sell it.
Okay, so
And okay, so anyway, I completely agree with this court's opinion. Okay, 100%. I also represent some property owners. And it's always like, oh, I got this cannabis guy that wants to rent the place. And, is there a law about that with the federal law and everything? And I've been telling him for years. I think maybe a couple of weeks ago, I had one and I said, well, it might just slide by, but it's still a Federal Controlled Substance Act issue. And you know, banks. I mean, as far as I know, even legal, lawful cannabis clients that I have, they have issues with banks. Okay, so this whole issue of preemption, it's real, notwithstanding the California statute. So this cannabis grower that decided to like get that landlocked property, well, they should have been a little nicer to that person with that easement, get their consent because that's the bottom line. To get that CUP, you need the consent of a property owner, and that guy that had that servient tenement is a property owner and they needed his consent. So I completely agree with this.
and whether it's, I don't know if it's Crandall, if it's Randall, I don't know how, the name is there. I wonder if they just raise this position to increase leverage, right, over Santa Rita Holdings, uh, maybe to try to get a change in an easement, to get an increased payment for the easement, to get some kind of monthly retribution, for the use of the property as a result of this. We cannot tell from the case itself. I know there's a lot of instances in residential landlord-tenant law concerning cannabis use, and maybe the landlord goes to court to try to stop it. At least this case here would be one case that could be used by a property owner to say, if the lease is silent on the use of the property for growing or using cannabis or marijuana, this is one case that I think property owners are going to find quite useful in that context. Just from what I've heard, last month we had on Anna Lou, and it's just some courts say, that's okay. You're in California. It's okay as long as you are, you don't have more than the number of plants that's allowed to be grown, et cetera. But this case is going to give some property owners much more leverage in that situation where their lease is silent on the issue.
Yeah, and that's really common that tenants they just do whatever they want, and these cannabis grower types, they really, I mean, they do whatever they want. And then the landlord has to say, hey, you're violating the law, and it happens. It's a very common thing.
All right, so let's move on to our next case that also involves cannabis. And this has to be my favorite case today because you have the Mullers who were married in 2009. They had a cannabis business. They were cultivating cannabis, and I love this. They buried the proceeds on their property. So I guess they figured buried money was better than investing money in the stock market over the course of these years, because maybe it was more difficult to be caught in this situation. All right, so they buried money. How they buried it, whether it was cash, whether it was gold, whether it was coins, I don't know what they buried, but they buried the proceeds of their cannabis business on the property. Well, lo and behold, the Mullers get a divorce, or they're going through the separation and divorce process. Something that is new to me. I'm not a family lawyer, but there's something called a collaborative family law process that does not have to involve third parties. And in this particular case, and when I say does not have to involve third parties, I mean it does not need to involve, for example, a mediator, a third party mediator. The parties can be represented by counsel, but essentially they're engaged in a negotiation in an effort to resolve a marital dispute. They sign an agreement. The agreement says this does not create any enforceable terms on either party. And as part of that agreement, they have language that says, guess what? Anything that's said during the course and scope of this collaborative process is confidential. Well, during the collaborative process, one of the spouse, Ling, it is asked about, and her attorney is asked about, what about this money that was dug up and spent, and some of it spent out of the country, and some of it was spent, I think, on antiques? What about this money? Because the other party who says, well, that is essentially community assets, and you dug it up and you took it and you bought some property, I think they said in China, and you bought some antiques. Hey, I'm entitled to half of that amount. I was entitled to half the amount of the money, that buried treasure on our property. And there then became a dispute. Ling walked out of the collaborative process, became a dispute later on going to court, which is, can any of those admissions be admitted to a subsequent court hearing? Okay. Was that confidentiality clause as part of the collaborative process, was it enforceable? And you see the trial court said, well, when we look at the collaborative process, even if you have confidentiality, that can be waived if money has been spent that causes irreparable economic damage to the assets. Well, the money's gone. What could be more irreparable than that? It's gone, and there's no way to retrieve the proceeds if they are in some, personal property that's stored somewhere that no one's going to tell, or in real property where it's not possible to access that. Ling said you can't use my testimony, the testimony of my lawyer in that collaborative process. That's not allowed. Went up to the appellate court. The appellate court said, well, guess what? The agreement itself, the collaborative agreement, says this agreement is not legally binding. So if the agreement is not legally binding, then a confidentiality clause within the body of that agreement is not binding either, right? And the court said, we're just going to look at some basic contract interpretation rules to make that finding, and it's not that difficult to make that finding. My quote down at the bottom, we published this case to highlight the importance of carefully drafting collaborative law agreements. And Michael was talking a little bit earlier. Unlike mediation, our legislature has not created an evidentiary privilege for the collaborative law process. And it cites to the two different laws, the Family Code and the Evidence Code. If parties intend to keep the process confidential, They are responsible for drafting an enforceable contract that so provides. So, Michael, again, I don't know very much. I don't know anything about family law, but I was reading this case and I was thinking, wow, might it have applicability outside of the family law process? Because the court used a lot of contract interpretation language. Could it affect something like a letter of intent, where parties say up front, we don't intend this letter of intent to be binding, we're kind of setting the terms? Could it affect a memorandum of understanding that may not intend to be binding at the time it was written and maybe even signed by parties? What do you think about anything like that?
I have read about letters of intent, and sometimes people write letters of intent and they say this is not intended to be binding, to be followed up by a written purchase agreement. Sometimes they don't. And that's, I think, the initial inquiry you have to make. Okay. But I see that coming up. But what is a contract? I think we've even had cases before about, I've had cases where you want to use the statute of frauds, but the statute of frauds is not a substantive rule of like evidence. Okay, if you can prove some agreement, you can use other ways of proving an agreement. So that's an interesting area. I think we can find some cases on that because they come up all the time. But I think this case here that we're looking at, I always say this, you know, courts, including appellate courts, have common sense. Okay, this case has unique facts and illegal acts, right? So I think when they're talking about marijuana proceeds and money and digging it up and doing this, and I don't know why they're using this collaborative law process that an agreement that says per se, this is unenforceable. What's the point? It's kind of crazy. Um, but I think what's important here from a technical point of view is this collaborative law process. And I've had people ask about that. Um, they come up and they say, "Oh, we saw this on the internet. Can we do that?" And I saw this a long, long time ago. I said, I don't know if we need to use that phrase because we're going to use it neutral. And I think that's designed when the parties have lawyers, or for some reason you get a waiver and one lawyer wants to basically represent both. But the issue with mediation is there's a neutral person involved, and that's why you have the evidence code protections. And this collaborative process, the way it's phrased, is there's no neutral involved, and that's the big difference. I don't know how it seems like it's adversarial, but it's not supposed to be. Kind of a weird thing.
So, Michael, I want to thank you. For those who are listening today, if you look in the chat, you will see a link to a PDF document that gives an explanation of collaborative law process. And I think you said that came from the Riverside County Court. Is that correct, Michael?
Yes. I mean, there's a lot on the web, but I figured that one looked more official. And it was a good summary.
Okay, so for those who are interested, copy and paste or click on that link in the chat box. So, anyways, another good case. Maybe it will be narrowly applied. Maybe, it might be more broadly applied depending on how one drafts a contract document. I know a lot of times in real estate transactions, there is confidentiality. There's confidentiality of price. There's confidentiality in many cases of who the purchaser is for the property. So you've got to be careful if you have something that's not a legally enforceable document that is establishing or attempting to establish some type of confidentiality. And if you are involving a third party to facilitate the negotiation between the participants, then you want to make sure you get the appropriate document signed as evidenced by the California Evidence Code. So great. So let's move on, Michael, see what else we have to talk about today. West versus Solar Mosaic. So you were talking about, cases in the courts applying, common sense, or the courts applying, some kind of element of fairness. I think that's really sums up this West case. You have a situation where Mittmager or Mittmeijer as a sales representative for a home remodeling company, visits an elderly couple and their elderly daughter, Dion, at their home. Both Harold and Lucy, the owners of the home, were in their 90s. Look at this. They suffered from dementia. They lived off their Social Security payments, right? So you're not dealing with wealthy people here. Neither used email, computers, or mobile phones. So you had the sales representative. He's discussing a solar program. Anyone who's had a solar program knows, hey, they may be great. Get all this energy to power up your electrical vehicle. I'd kind of bet that the West did not have an electric vehicle in their home, right? And you can save on your electricity bills, but you're paying either upfront or you're paying over time for the installation of those solar panels. Well, as part of that discussion, they'd also talked about a bathroom renovation of $25,000. So again, a lot of money for a couple who is living off of their Social Security payments. And, my guess is, do they really need, a brand new bathroom? I don't know. So while the sales representative's there, talks with the lender, he sends over electronically a 33-page long loan document package that is sent to Dion. So this is the daughter's email address. Now look at this, because I know I hear something similar to this in a real estate context all the time. The documents were sent at 6:29 p.m. and 20 seconds. They were viewed 10 seconds later, on the mobile device. So maybe it was a phone, maybe it was a tablet, I don't know. And they were signed electronically in Harold's name, right? So Harold, who doesn't have a mobile phone, doesn't use email, doesn't have a computer, somehow, logged on to this email or tablet, figured out all these 33 pages, and signed 7 times within the next 13 seconds. So, of course, after the work began, there were some problems with the work, and the West and the daughter as well contested the validity of the contract. Mosaic says, well, wait a minute, there's an arbitration clause. We're going to have this matter sent to arbitration. So they brought a motion to compel arbitration. The trial court said, well, in order to have a motion to compel arbitration, you have to have an agreement to arbitrate. So in order to have an agreement to arbitrate, you have to have an agreement. Where's the agreement? So look what the appellate court said, and there's 2 issues that were really decided. The first issue dealt with the proof of the signature. And they said, well, guess what? There is at least, right? There is a question of fact as to whether you had a valid signature here. And Michael, you were talking in your tip, earlier on. Find out information about your client. Find out information about what's going to happen in this transaction. Gosh, you'd think the parties could have found out early on that Harold and Lucy don't use email, don't use computers, don't have mobile phones, that they're living off their Social Security payment, and somehow they agreed to a bathroom renovation in 13 seconds online for a $25,000 fee, right? So I'm guessing a lot of this could have been found out very early in the transaction. The court said, listen, it's doubtful that they really signed, but it's unquestionable, okay, that there's a factual dispute as to whether there was a valid signature. So for that alone, we're not going to allow the motion to compel. I'm going to go to my next slide, and I'm going to turn it over to you, Michael, because there was another argument that was made, and maybe the parties could have saved themselves some time in that first argument, because the other argument that was made on behalf of enforcing this agreement was, well, okay, in the alternative, we'll say we acknowledge that Dion, the daughter, signed. Then the issue is, did the daughter have authority to sign on behalf of the parents? And the court says here, or Mosaic basically was saying, well, there was a phone call. There was a phone call where they put Harold on the phone, and they're asking Harold questions that he basically couldn't answer, like, your name, your Social Security number, how old are you, what's your phone number, let alone questions about do you know that you're agreeing to a $25,000 renovation of this home? Right? So the court said, well, you know, if you're going to argue ratification, at the very least, there's a question of fact as to whether Harold really could ratify when he couldn't answer the simple, most basic question about what was going on. My favorite fact here, it's sad, but it's my favorite fact in the case. After Dion, the daughter, attempted to cancel the contract, Elite stopped their work. They stopped their work after completely tearing out the bathroom, leaving Harold and Lucy to bathe in their kitchen sink. So, boy, you talk about bad facts, Michael. What do you think?
Okay, so Neil, I gotta say, first thing is I applaud the attorneys that help these poor people out. Okay, and this went on an appeal too, and I have some strong opinions now about Shepard Mullen. Okay, on this case too,
Yeah.
but it's all about the facts. And yeah, actually, this is a case where I know pretty well the trial attorney and the justice that I guess authored the opinion. But this is a great case. This is I don't understand how this case got so far. It's crazy. But it has some applicability to real estate cases. You know, all the time people are docu-signing, and you send a docu-sign to someone, and are they the one in charge of their computer or their phone? Are they having their wife sign it, their daughter sign it? Like, who's signing? Who has control of the email? You know, it's an issue, right?
It's definitely an issue. I can tell you that, you know, where I work, which is the California Association of Realtors, we advise realtors whether they're working with a buyer or working with a seller. It does not matter. We say, send them a copy, a blank copy of a purchase agreement in advance so that when the final agreement is being sent for them for signature, they're not looking at a multiple page document for the very first time and somehow initialing and signing, you know, within a few seconds. And then you know, you're just it's too easy for somebody to argue at that point, right? I was intimidated into doing it. I didn't know what I was signing. I didn't understand what I was signing. We always advise real estate agents, make sure your client has seen the document in advance. They know where an arbitration paragraph is that requires separate initials. They can know where a liquidated damage clause is that requires separate initials. They know that it's 16 pages long and here's where you're going to sign at the end so that you send it to them in advance. You can send it to them electronically in advance. Now you've got some record that your client has been informed as to the nature of the agreement, so they're not seeing it the first time when they're asked to sign it.
And I see another practice pointer here. Like I said, Shepard Mullen, I don't know what's going on there, but on the last page of this opinion, and this is something that I mean, common sense is there, but I didn't know about it. They talk about some arguments, and apparently the Mosaic company was also arguing ratification because the property owner, say, accepted the benefits of the loan by getting some of the work or that's house destroyed. But in the Court of Appeal opinion, it says Mosaic's cursory, insufficiently developed argument in a footnote, and that's the thing, in a footnote, that Harold ratified the agreement by accepting the funds. They didn't like that. And they cited a bunch of cases here that say footnotes are not appropriate for stating contentions on appeal. And another one, I like this one. We do not have to consider issues discussed only in a footnote. And that's citing a California rule of court. Okay. So whoever they gave to draft this opinion has put in kind of like an important issue like ratification by accepting the benefits of the loan into a footnote that directly contradicts the California rule of court rule. That's kind of crazy. Like I said, surprising.
So it is kind of crazy, Mike. And you know, I have to tell you, my first thought was the same as you, which is, how did this case make its way to an appeal? Who thought that this is a great case to take up, right? Given given the facts and just the sympathy that one would have for the property owners in this case. I'm surprised when I see a case like this that somebody is willing to spend the funds necessary to take a case that far. But takes all kinds, I guess. Okay, Michael. So let's do our last case then. In Ray O'Gorman versus Hoffman. Kind of have an interesting situation here. And again, it relates to a situation that we used to hear a lot about in California. And maybe we will again if situations turn around in a negative way. So the O'Gorman lived in a house on a 30-acre property. O'Gorman's former attorney placed a junior lien on the property. And when O'Gorman defaulted on a senior loan, the attorney cured the senior loan, $300,000, and then commenced a non-judicial foreclosure. Okay, just like any junior lien holder would do if there's enough equity in the property. In this property, there was different estimates that the property value, I don't know the loan amounts, but the property value was somewhere between $2.5 and $3 million. Well, O'Gorman either reached out or was contacted by Utenhammer. I'm not really sure how to pronounce that last name. Sorry about that. Who said, "Oh, I could save your property from foreclosure. Put it into this irrevocable land trust. Then the lenders won't be able to foreclose on your property." And we heard a lot about this, right? When property values went down, right? When you're thinking 2007, 2008, 2009, hear a lot about this. Parties wanted to stay in their house. They found out of this. I mean, I've got to call it a scheme. I don't know what else to call it, to, in my view, trick homeowners into thinking you can avoid a foreclosure by transferring your property into this irrevocable land trust. And there's some kind of co-ownership agreement, and there's different rights regarding payment. Any event, at some point, O'Gorman said, enough of this. Forget that. I'm canceling that. I'm just going to file for bankruptcy. Okay, bankruptcy is a legitimate way to at least postpone or delay a foreclosure process. And, during the bankruptcy, the trustee sought to undo the transfer of the property to the land trust. So Utenhammer, who had the property in the land trust and was one of the, principals in the land trust, opposed. The trial court said what? The bankruptcy court granted summary judgment to the trustee, said, yes, this is a fraudulent transfer. That was upheld by the bankruptcy appellate court, which, upheld the summary judgment. And then you have Utenhammer appealed. The argument in the appellate court that was the purpose of this decision was, well, the creditor, which in this case would have been the attorney, was not really harmed. Why was the creditor not harmed by the transfer? Because the court subsequently determined that the attorney's lien was invalid. If the attorney's lien was invalid, how is the creditor harmed? By transferring the property into the irrevocable land trust. That specific creditor was not harmed because he was not really a secured creditor. The bankruptcy court said, that's not the rule in bankruptcy court. The rule in bankruptcy court is that no harm is required to undo a transaction as a fraudulent transfer. What is required is that there is an intention to hinder, delay, or defraud any entity to which the debtor was indebted. Whether taking this asset with a value of $2.5 to $3 million, I don't know, what kind of equity there was in it. And O'Gorman acknowledged that the reason they did this was to avoid including it, to avoid the foreclosure. So there was an absolute admission from the property owner that this was done basically in violation of the bankruptcy law. The court said it is not necessary that that particular creditor be harmed. What's necessary is that there was an intent to, what did we say, hinder, delay, or defraud. Michael, before we go on with our announcements. What do you have to say?
So I completely agree with this Court of Appeals opinion. I like that they went step by step and they went through to say what's wrong, either the fraudulent transfer and hinder. They also spent some time, the lawyer or whoever, I guess, the same guy, whoever he's doing in the trial court, um, he really screwed up. This is another civil procedure thing. The the summary judgment rules in bankruptcy court are very similar also to the state court, but the guy just didn't oppose the motion for summary judgment correctly. I mean, if you wanted to have a delay to conduct discovery, you have to not only like serve the discovery, but you have to tell the court, you have to file a paper that says, I need some more time to finish discovery and get a continuance of the hearing. He didn't do that. And the court went through all these little reasons that the lawyer screwed up, um, not opposing the summary judgment motion correctly, but he couldn't do it. I mean, there's just no way the guy's going to win this case. But I guess he had a lot of money at stake and he was trying to find a way to make some for himself. And like you said before, Neil, this issue about transferring a part, it used to be, I saw this before, I don't know, it was 20 years ago, it was a long time ago. Some paralegal or someone would come and say, just transfer to me like 5% interest, and then they would file bankruptcy of that 5% interest. That was a long time ago. So it's kind of like that scam trying to do it again. You need to come up with a new concept.
Well, I hope they don't, but you know what, there's people are never at a loss for coming up with new concepts. Let's do our announcements before we take off. And what's coming up at the real property law section? Well, next month, not as part of What's Up With Us, but as part of the real property section webinar series, I'm going to be conducting a webinar with two attorney colleagues, and we're going to be talking about real estate broker compensation and the NAR class action settlement, how it came about, where it stands now, and what brokers are doing in California in response to all of that activity. And then also in December, something that sounds very interesting, Intro to International Real Property Mediation, and that's going to be on December 12th. And, Brooke, who is our coordinator for the real property law section, Brooke, if you would not mind, you could put up, if you have them, ways to register for either of those two. And we always want to remind you, we'd like to remind you, in advance, the real property law retreat is coming up. It's March 7th through 9th. And I'm pretty sure that's going to be in Monterey. If I remember correctly, it's going to be in Monterey this upcoming year. So just as a reminder to you, a lot of different ways to get involved with the real property law section. Thank you, Brooke. I see you. Brooke just put up in the chat ways that you could register for those events. And I say a lot of ways to get involved in real property law section. I am pleased to see that one of the newest members of the real property law section, Rick Schroeder, is there and in attendance today. So welcome, Rick, and hopefully you will bring lots of your colleagues and friends and real estate law acquaintances to join us at the next What's Up With Us. You can see right there, we're not going to have What's Up With Us next month. We're taking December off, but we're going to be back in January. Part of the discussion in January is we're going to discuss some of the new laws impacting real estate. There's a lot. There's no way we could go over all of them, but we're going to be talking about some of the ones that Michael and I think are the most crucial new laws affecting real estate. And until then, comments, questions, suggestions, interview ideas. We need to have an interview this month. We do like to do interviews of interesting real property law practitioners. And again, as I think probably everyone here knows, What's Up With Us is available for 1 hour of MCLE self-study credit. And next year, at least a couple of times, we're going to take Michael Simkin's secrets and we're going to use those for, we're going to have Michael doing an expanded Simkin secrets, and we're going to try and get you a half an hour of some of the specialty hard to get credits.
And by the
That's it
way,
for me.
wait, Neil, don't forget, I
Yeah.
have a website. It's a blog called attorneysecrets.com. That's
Okay.
attorneysecrets.com. Check it out.
Attor- attorneysecrets.com. Well, that's gonna be great, Michael. You can just pick up one of your blogs and it's gonna be a big help to all real property law section members that want to get some of those difficult, hard to get credits, before they're every 3 years you have to renew. Michael, nothing else from me. I hope everybody has a great December. I'll be back in January. You'll be back in January. Michael, how do you want to end us up today?
I want to actually encourage people to attend your webinar about the settlement because on the new car forms, I was reviewing one yesterday and the whole issue about broker compensation comes up. And I know a lot of brokers are trying to get really creative of how to deal with that. So I think it's important that they understand what the parameters are.
Well, thanks for the plug, Michael, and we hope people sign up and we hope people join us for that webinar. Got really great attorneys who are joining us, who give advice to thousands of real estate agents that they have as clients throughout the state. So their insight is going to be incredibly valuable as well.
All right. Well, thank you, Neil.
Thank you, Michael. Thank
Have
you,
a
everybody,
great
for joining us.
December.
Uh, See you in January.